Well, good afternoon, everybody, and welcome to today's talk on artificial intelligence at EU borders, a human rights perspective. I'm Professor Francesca Bignami. I teach EU law here at GW, and it is my great honor and pleasure to be introducing today's speaker, Professor Nyovi Bavula. Professor Bavula, her home institution is Queen Mary University of London School of Law, and so she's just joined us from London. But this semester, we are very fortunate to have her as a visiting scholar at GW Law. Professor Bavula writes and teaches in the areas of EU migration, criminal, and data protection law. And her book, Immigration and Privacy in the Law of the European Union, The Case of Information Systems, I'm very happy to report is going to be published as we speak. It's going to be published in a couple of months, so keep your eyes out for that new work of hers. She has served as a visiting professor at ULB in Brussels and the University of Bologna, and she is also the associate editor of the New Journal of European Criminal Law. Professor Bavula will speak for around 40 minutes, followed by Q&A, and I very much encourage anyone in the audience to pose a question. I ask that you put them in the chat, and then I will actually ask them to Professor Bavula. And I will stop there, and very much looking forward to Professor Bavula's talk. You're welcome to take the virtual floor now.
Thank you so much, Professor Bignami, for this very, very kind introduction. And I would like to thank everyone who is joining for this talk, Dean Celorio, and Selena, and everyone else that I have been corresponding in the past months. It is a really, really great pleasure that I made it to Washington, D.C. as a visiting scholar, and I will be here for the next couple of months. So already at the outset, I would like to express my gratitude. And if anyone wants to get in touch with me, by all means, feel free to get in touch, to email me about anything that you may think I can be of help. Give me one moment to share my screen. It should be able now to see my presentation. So what I'm going to present to you today is a topic that I have been working in the past months, and it is the starting point of my research that I intend to do this month at GW Law. And it is a topic that I have already worked in a publication for the European Journal of Migration and Law. So the article is already published if you want to have a further look at the arguments that I'm going to present to you today. And the idea is to take stock of how artificial intelligence tools and systems have already been used at the EU level or will be used in the forthcoming years, and how this affects the protection of human rights of migrants, asylum seekers, and other categories of foreigners, or as we call them at the EU level, and you may hear me call them in the next minutes, third country nationals. So whereas at the EU level, you may have heard that there has been a lot of discussion about the forthcoming AI Act, so a horizontal proposal that is going to be regulating the use of artificial intelligence systems in the EU member states in the future, I wanted to take a step back and look whether artificial intelligence systems are already embedded or are systems already anticipated to be used in information systems that collect and process data of foreigners. And in that regard, I will be speaking about two case studies, basically how algorithmic profiling is going to be taking place and how facial recognition is also going to be used at the borders or at national level for immigration purposes. And finally, the last slide is mostly an overview of what else is happening at the EU level apart from these two case studies. And of course, feel free to ask any questions at the end on any of the topics. So in order to provide you a bit of context of what is going on at EU level as regards the collection and processing of personal data of foreigners, the EU legislature has opted for a compartmentalized approach, whereas there is no overarching one database that collects and processes the data of all foreigners at once, be it irregular migrants or asylum seekers, but rather for data protection, privacy reasons, but also because technology didn't allow that, there are a series of databases that target specific groups of non-EU nationals. And these databases are operated by all member states that are part of the Schengen area. Schengen area is not the same as the European Union. Schengen area is for our countries that have abolished internal border control, but have a common external border and are not the same as all the EU member states. For instance, Norway or Iceland, which are not members of the European Union, are part of the Schengen area, whereas Ireland, for instance, is a member of the European Union, but not a member of the Schengen area. So the databases that we talk about are primarily Schengen-wide databases and are regulated under EU law. So the member states have to abide by EU law standards and cannot do what they want on their own at national level. And these systems that I have put here on this slide provide you an overview of this compartmentalized approach. And we have, for instance, the oldest one, which is the Schengen Information System that processes data of irregular migrants or are criminals. So its purpose is mostly to prevent the unwelcome foreigner from entering. The visa information systems, as you understand, is a system that processes data on visa applicants, both short stay and long stay visa applicants, like resident card or permits holders. Eurodac is a system that processes data on asylum seekers. So an asylum seeker will have their data collected and stored in Eurodac when they apply for international protection. And then these are the operational systems. However, there are three additional systems, the one listed under black letters, which are currently in the making. So over the past years, the EU legislator has expanded the reach of information systems by having an entry-exit system. The entry-exit system is very close to what is the US visitor or ident program. So it is basically a checking in and a checking out system whereby whoever comes and goes will have to provide that information. So as you check in at the hotel and you provide information, and when you check out, you again provide some information and you leave. This is what the entry system is going to be doing. The ETIAS is basically the US ESTA system. So it is a system that is very similar to VIS, but only for visa-free travelers. So visa-free travelers have to get prior authorization online before traveling to the European Union. And this is exactly as the ESTA system in the US is working. And the final system that is going to become operational is a system that is going to collect data on convicted foreigners, and it's called European Criminal Records Information Systems for Third Country Nationals, or ECRIS-TCN. So I'm going to be using these acronyms. I hope it's not too confusing for you, because it is a very complicated architecture of all these information systems, but this is what we're working with at the moment. As if this is not complicated enough, these systems are going to become interoperable. What does it mean? They're going to interact in one way or another in order to allow authorities to get even more information about foreigners. And I know this is a very complicated diagram, and in order to assist you in understanding it, basically what interoperability means is that basically all the biometric data, fingerprints or facial images, are going to be stored together. in what is called shared biometric matching service. There is going to be a separate catalog, like an index of all third country nationals from the systems. So basically, the basic data of all the databases that we discussed are going to be placed in one spot together, like a catalog, like the yellow pages of all the third country nationals, to see where they belong to which database. And all searches are going to be taking place through one portal. So a border guard, for instance, will not have to go through every database one after the other to check the systems, and will have to go through just one portal and get the information in just in one screen. This is the context that I wanted to provide you, to give you a bit more understanding of what we're working with. And as you appreciate, these databases collect and process data of millions of foreigners, from Eurodac, which has 8 million records, to the forthcoming entry and exit system, which is expected to have more than 60 million records. So we're talking about large amounts of data, some of which are sensitive personal data under EU law, particularly the biometrics, the convictions of third country nationals. These are primary data that require additional protection. So where does artificial intelligence systems and tools fall within this very complicated architecture? So as I told you, I'm going to be discussing with you two main examples. The first one is how algorithms are going to help in deciding who gets authorization to come to the European Union. These are fairly recent developments, which maybe at US level, you may consider them as quite rudimentary. You may already have this. The reason why I'm here is to see whether this is the case. But at the EU level, we're talking about some very, very recent developments. And the two examples that we have of algorithms assisting in decision-making are the cases of VIS and ETIAS. In other words, these systems are going to enable decision-making on whether someone will get a visa or will get a travel authorization if they don't need a visa, on the basis of algorithmic profiling. So in the case of ETIAS, not only, actually the decision is going to be heavily based on algorithms. So the pre-vetting of travelers is going to take place, one of the ways in which it's going to take place is through algorithmic profiling. But in the case of the visa information system, there is no automated decision making. It's just that the system is going to assist humans, the immigration authority, the visa authorities, to make a decision by flagging potentially risky travelers. So the position of algorithms in this process is that among the different elements that are going to be cross-checked when someone makes an application are algorithms, screening rules as they are being called, which are going to be able to flag out potentially risky travelers. So the risk assessment that is entailed takes place through cross-checking of data in other information systems or Europol data. Europol is a bit like the FBI, CIA, but with no enforcement powers as these agencies, as well as certain Interpol databases. But what I'm going to focus more is how the algorithms are going to be defined and how they will work. The idea is that rather than focusing on each specific traveler, the idea is to do this pre-checking, this pre-screening before their departure, in order, on the one hand, to facilitate travel for considering low risk profiles, whilst allocating more resources into looking in more detail, closer, potentially risky individuals. So the algorithms are going to assist in saying who is a risky traveler, either a visa applicant or a non-visa applicant. So a little bit discussing on what is there on algorithms and automated processing under EU law. So the topic that we are discussing, it is the one that has evaded scrutiny by the European Court of Justice completely. However, there are other judgments by the Court of Justice which have given us some indication on what are the standards that we need to apply in order to have algorithmic profiling, that it's not discriminatory, and that it abides by the rights of privacy and data protection, which are under EU law are separate. So if we go to the GDPR, the General Data Protection Regulation, which is the primary data protection piece of legislation at EU level, we know that the data subject has the right not to be subject to a decision based solely on automated processing, including profiling, when it produces legal effects concerning them, or at least it similarly significantly affects their status. So we know that that's a basis. But the decision of the Court of Justice gives us a little bit more detail about how algorithms should be determined. And in Opinion 115, this was a judgment that concerned the transfer of PNR data, so of passengers' data. When you book a flight, the data that you book about the flight are being transferred to law enforcement authorities. These are the PNR data. It was said that the pre-established models and criteria, in essence, the algorithms, should be specific and reliable, should also be non-discriminatory and limited to what is strictly necessary. So we do have a threshold as to what is a lawful algorithm profiling under EU law. It also said that the databases must be reliable and up to date, every hit must be examined individually, and all the algorithms must be subject to periodic review. So these are the standards that the Court of Justice has already set. In a more recent case, after Opinion 115, we also learned that the models and criteria cannot be based on sensitive data in isolation. So we need to keep that in mind as a standard as well. Let's start applying this criteria in the present case to see whether we do have any problems, whether the rules on VIS and ETIAS are potentially discriminatory and thus pose challenges to the principle of non-discrimination. So if we go back to the ETIAS and VIS regulations, we see that the algorithm profiling will be done on the basis of risks that are going to be defined by the European Commission. The European Commission is not exactly the government, but it is the executive, on the executive side of the European Union. And obviously, in order to create algorithms, you need a lot of data. So you need a lot of data in order to create statistics, and on the basis of these statistics, to create the rules as to who is a risky individual. For instance, if the statistical data show that men over the age of 30 from a particular region of Afghanistan have been irregularly staying more than women of the same region, then you have potentially one algorithm that is going to weave out those individuals and when they apply for a visa, for instance. So that would be how an algorithm would operate. And these statistical data are going to be based on data that the systems themselves are going to create. So have in mind that we're talking about systems that haven't even started their operation yet. So already we rely on systems that are going to operate in a few years to create statistical data in order to create the algorithms. So it is a bit premature, one might say, to rely on databases which we do not know whether are going to be reliable and whether they are going to have any problems in order for them to form the basis for the algorithms. In the meantime, and because in order to generate data from systems that do not operate yet, they're going to be the member states that are going to give the data to create the algorithms. So the states themselves are going to give information about abnormal rates of overstaying or abnormal rates of refusals of visas or authorizations. And the fear is that there is going to be potential abuse of these algorithms, of this possibility for member states to actually promote their national policies and try to exclude from getting visas or authorizations individuals which otherwise shouldn't have. And before going to the next slide, the last thing that I wanted to say in that regard is that the other thing that could be abused is the possibility to have algorithms on the basis of diseases and epidemic standards. And the fear is that the current pandemic is going to provide the basis for member states to also use it in order to exclude potentially individuals from specific countries, even though in a pandemic, you can't really exclude anyone because we are equally in this together. Getting a little bit deeper on the discrimination risk that algorithmic profiling entails, if we go back to the legislation, we know that they're going to be, in order to create the algorithms, there are going to be specific risk indicators that are going to be used. So what type of information from statistics are going to be the basis to create the algorithms? And the legislation basically says that we are going to be using a combination of one or several categories of the following: age range, sex and nationality, country and city of residence, level of education. Obviously, this means that individuals with lower degree of education may be discriminated through an algorithm, current occupation, and member states of destination or first entry and the purpose. I'm going to discuss a bit more what are the risks of all these categories to be used. But in principle, the legislation says that the indicators should be targeted and proportionate. So the idea is that there's not going to be discrimination. However, if we look a little bit deeper, as I said, algorithms operate on previous data. So they are destined to replicate implicit and inherent biases of earlier decision-making. So if, for instance, border guards have been discriminating for years against specific groups of individuals or visa authorities, and this creates statistical data, this decision-making is going to fit into the algorithms, and the algorithms are going to continue discriminating against those groups of individuals. On the plus side, the risk indicators should not be used based solely on a person's age or sex, but the regulations say nothing about the combination of the two. So we don't really know what will happen. Like, for instance, a woman over the age of 50 could be an algorithm in itself. So again, this is a bit problematic. The other thing that is a bit problematic is that though we know from the case of La Quadrature du Net that I mentioned earlier that sensitive data should not form the risk indicators, should not be the risk indicators in isolation, we also know, and we can assume, that designating sex may often indicate sexual orientation, city of residence may reveal ethnicity and color, level of education and occupation will indicate property and trade membership, and nationality may be a proxy for race, ethnic origin, and religion. So the potential, even if there is no potential for direct discrimination, which we cannot exclude it, there is definitely potential for indirect discrimination. And at the moment, at EU level, there is no standard from the Court of Justice, which basically prevents indirect discrimination. And to give you a bit of an insight, a couple of months ago, I was providing a training to Frontex, which is the agency that assists member states in the management of external borders. And there was, they were saying that because they are going to design the algorithms, actually, we know from the beginning that it's going to be impossible for us not to discriminate against certain groups of foreigners. So there is already knowledge that the legislation cannot be compliant with human rights, particularly the EU Charter of Fundamental Rights, which is binding to all member states. One might ask, you told us earlier that there is a proposal for an Artificial Intelligence Act at EU level, and indeed that's the case. Maybe there is protection to foreigners from the new act. However, Article 83 excludes all information systems from its scope. So whatever is going to be done with information systems is going to fall outside the scope of the AI Act, unless in the future there's going to be a major change. The problem that I have with this provision is that, as you may have already understood, these are already things that have been set in law. So they haven't already been tried and tested, but they have been set out in law, which means that what was the major change has basically already happened. So the systems are going to be destined to be outside the AI Act. There is a lot of discussion as to whether Article 83 should be amended, but for the time being, what we're discussing is completely outside the scope of the forthcoming AI Act. So the second case study that I wanted to discuss with you for a few minutes is how facial recognition is going to be used at the EU borders. So I've already discussed how algorithms are going to assist in decision-making of visas and travel authorizations, but in the meantime, the majority of information systems, apart from ETIAS, because it's based on an online application and it's impossible to collect facial images, all other systems collect fingerprints and a facial image. And the reason why there is this emphasis on facial images is because there is an anticipation that facial images are going to be used in the future through facial recognition technology, either at ABC, automated border control gates, or for identification when someone is at the border, or even identification of national territories. So the systems, and this has already been tried in different projects, are going to be seeing a face of someone as they approach the border and do the cross-check against the systems in order to identify even before the person hands over their passport. So that's the idea. And not only at the borders, but this is going to be done also on national territory. Facial images, however, I told you already, these are biometric data which are under EU law, under the GDPR, specifically its Article 9, are considered special categories.
Hello, everybody. Am I the only one who's lost the audio?
No, she's frozen on mine as well.
Okay, Rosa, do you have advice?
I just emailed her.
Okay.
I lost it too.
happened. It was beyond my sphere of influence. I was completely out of the meeting. So apologies for that. I know you're dying to know more about facial recognition. So without further ado, I'll try to continue my presentation. Hopefully this is not going to happen again. So as I was saying, facial recognition is already anticipated in the systems. That's why they collect facial images apart from fingerprints. And however, sometimes it's not entirely clear how facial recognition technology is going to be used in the future and what will be the uses of the facial images. And one such example is the case of the Schengen Information System, because if we go to Article 25, Paragraph 4 of Regulation 2018-1861, we will see that the Commission sometime in the future may decide to use facial images for other uses, which are completely undefined in law. Obviously, this creates a legality problem. Like, it creates foreseeability for individuals, for foreigners, to appreciate how their personal data will be used in the future. So they could be used for surveillance on the ground, for purposes outside immigration control, without the knowledge of the person concerned. And the fact that we know that facial recognition is the future, it comes from the Eurodac proposal, which basically says that facial images are important, so searches to be made with facial recognition software in the future. So we already know why this is happening. What are the problems with that? Obviously, there are some challenges. And one key challenge that we have is that any degree of accuracy in facial recognition technology is crucial for false matches. So we need good quality data in order to produce good outcomes. So we need good facial images so that the recognition is going to be as accurate as possible. And depending on the context within which the facial images are going to be collected, the errors may be significant. And if the errors happen more often, also the consequences for foreigners are quite important. And they can vary from secondary checks, which can be a bit degrading, humiliating, discriminatory, quite problematic, but also the errors may lead to refusal of entry, refusal of a visa document, and generally foreigners may be seriously disadvantaged on the basis of facial recognition technology. And as I told you, data quality of biometric facial images is really crucial. And the problem that we have already is that research shows that facial images in operational systems are not always of high quality because of the need to speed up the process of fingerprinting and of collecting the facial images. Sometimes the border guard may lower the quality of the facial images in order to do it more speedily, rather than asking for the foreigner to pose once again and again until the facial image is of really high quality. And the most worrying part, which has already hinted, is that we know that these facial images may be used for surveillance purposes more generally, because the Commission Joint Research Council said that additional off-angle images are to be preferred for future potential uses, such as consultation using images acquired in unconstrained environments, essentially video surveillance footage. So in the future, these systems are going to move beyond immigration control purposes to truly embrace surveillance of foreigners for completely unknown purposes. Okay, so some standards that we need to have in mind are that the size of the information system will play a role in evaluating the error rates. Obviously, when you have a database with 60 million facial images, the possibility of errors increases if the facial images are not of good quality. Also, and have in mind that, as I told you, all facial images are going to be placed together. So we're expecting an overarching system of biometrics with more than 100 million facial images. So the errors may magnify because of that. The age of a facial image is also going to be very, very important. So if, for instance, a child which has been, the facial image of a child like 7 years old is being collected, and then 5 years later, he presents himself at the border and the data is still on the system, it is potential that the facial image is not, the facial recognition technology is not going to be accurate enough. And we have research that shows that depending on the age, the facial recognition technology is not as reliable. And the potential for public surveillance, it is quite significant because we don't know, because the legislation is not fully transparent as to the use and the future use of the footage. The potential of using it beyond the entry and exit to track and identify travelers it's important. This creates a chilling effect and really formalizes suspicion towards or against all foreigners. And the final point that I wanted to make on facial recognition is that we need to take into account the inherent limitations of facial recognition technology. It is something which is very new. It is based again on algorithmic processing of the facial images. And we know already from existing research on facial recognition technology that it is again discriminatory towards persons of color and women. So women of color are going to be particularly discriminated against unless facial recognition technology becomes really, really advanced in the future. And again, as I told you, the consequences for individuals could be significantly high. And we need to take into account that a foreigner is by default at a weaker position rather than a citizen. A citizen always has a right to entry under international human rights law to their own country. A foreigner doesn't have this kind of privilege and doesn't have this kind of relationship of trust with a foreign country. Just a very brief comment before I finish my presentation. I do believe I have maybe 3 or 4 minutes before I finish to place these developments within a broader context of other initiatives that are taking place at the EU level at the moment. And I don't want you to bombard with too much information. Already the topic is quite technical. Therefore, I want to just give you snippets of what is happening. So apart from the AI Act, which does not apply to anything that I have discussed, as I told you, there is a lot of ongoing projects at the EU level trying to test this kind of artificial intelligence tools, particularly emotion detection at the EU level. Emotion detection has been a very, very problematic aspect. The border control program is the one, if you want to have a further look. It is not considered to be at all in compliance with EU law fundamental rights. It's not reliable at all. And it has been recently challenged before the Court of Justice, also on the basis of transparency reasons. So because there was no information as to what was happening, what were the tests, and the project managers were not releasing such information. So the Court of Justice required the disclosure of more information on what this testing of emotion detection is happening. And we know that there is more to come because in 2020, the Commission issued a report which basically says that these kind of risk assessments are going to become even more prominent. So algorithms are going to triage visa applications between the low risk, the medium risk, and the high risk. This is again very discriminatory, and a similar triaging system in the UK has been abandoned because it was considered very discriminatory. And also decision on detention are going to be based on algorithms. So the algorithm is going to issue an indication, like issue an opinion, if one might say, as to whether someone is risky enough to be placed in detention as an asylum seeker or before removal. The agencies, the EU agencies, are being very prominent in getting a share in all these initiatives. Europol, that I mentioned, Frontex also wants to help in developing these algorithms, and also the European Asylum Support Office, EASO, had created a forecasting mechanism, like an early warning mechanism, which basically aim to analyze the prediction on migration even without a legal basis. So we see a lot of action taking place with lack of transparency, no really knowledge of what is going to happen, but really trying to get and see how artificial intelligence systems can be harvested in order essentially to exclude as many foreigners as possible. I'm going to finish my presentation here. If there is a couple of takeaways of this lecture, is that I hope to have established that still trust in technologies is not sufficient at the moment. The quality of data is a key in order for artificial intelligence tools to operate in the future. We should focus on the subjects of these tools, which are individuals at a disadvantage, and they have a weaker position by default. And it's not actually a surprise that these systems are first tested on foreigners because of the weaker position that they are. And the ultimate idea, like the ultimate goal for me, is to exclude them from protection. If they need protection as asylum seekers, as refugees, to try to exclude them as early as possible in the country of origin before coming, or even if they come at the border, to have additional tools to recognize them from afar. And because of these tools are going to be used through interoperability, interoperability really truly shows its true colors. So thank you so much for this presentation, and I'm looking forward to any comments that you have. This is the basis of my work here, so any comments or advice or any pointers would be very much appreciated. So thank you.
Thank you very much, Novi. Very, very informative and insightful presentation. We already have a question here, so I will go ahead and start reading them. It's a question from David Woodworth in my EU law class, in fact. And it says, could you comment on differences between the ETIAS Regulation 2018-2040 and the requirements identified in Opinion 115 and requirements or the use of AI by the United States for third country nationals entering the country? So I guess the contrast between what the the legislature is doing and the Court of Justice has said, and also the difference between the EU and the United States on these kinds of not visa waiver travelers.
Absolutely. Thank you so much for this question. So basically, the difference between ETIAS and Opinion 115 is on the scope. ETIAS is on visa-free travelers, and Opinion 115 concerns travelers who fly to other countries. Opinion 115 was particularly for travelers going from the EU to Canada. That was the purpose of that opinion, the scope of that opinion. And it was the transfer of data to Canadian law enforcement authorities. So, but again, Opinion 115 concerned the processing of the PNR data by the Canadian authorities through algorithmic profiling. So how the Canadian authorities used algorithms in order to sift the data that they had on the travelers. But the scope is very, very similar. And actually, and I know it's terrible to say, and I'm really sad to say it, the ETIAS regulation is not technically in violation of Opinion 115. It's that Opinion 115 is not enough as a privacy standard and non-discrimination standard. It is not enough. That's the point I wanted to make. In terms of what the US is doing with the ESTA, which, as I told you, ETIAS and ESTA are very much similar. What I know, because I've gone through the ESTA website, both as a traveler and as an academic, the processing of data is quite similar in the sense that I know from the website that my data, the traveler's data, are being compared to a series of databases that the US operates on migration and law enforcement. But the big difference is that I know that my data as an ESTA traveler are going to end up in more authorities than the data that a traveler with an ETIAS authorization will end up to. So the US authorities have a broader access to the ESTA data compared to the European regulation. So that's the difference. The other difference, which I hope to find out, is that I'm not entirely sure as to whether the US authorities have established algorithmic profiling. I'm not sure. I think that this is not the case, but I have to further investigate because it is partly what I'm going to do here. And because I find it quite interesting, this dialogue, this interaction. In the EU, sometimes we do things because the US have been doing for years, or Canada, which has ETA, a very similar system. But at the same time, I think we're a bit fast forward thinking in the EU, in the sense that we want a bit quite intrusive technology. I'm not entirely sure about the algorithmic profiling aspect of ESTA. If someone has any information, I'd be happy to discuss with you. But this is partly why I'm here, to find out more as to what the US are doing.
Great. Another question. Again, thanks for your presentation. And this is from Liz Kiriko. Do you know of any efforts to anonymize travelers' data and or to target risk-specific indicators only, excluding other personal data? So this talks about, I guess, anonymization techniques for protecting privacy. Yeah.
Thank you so much. That's a fascinating, a very interesting question. Actually, no, there are no anonymization techniques. Basically, the data of every traveler, asylum seeker, irregular migrant for the period that are retained in the specific system that has collected and stores their data are going to be available to create the risk indicator, to create the statistical data and the algorithm, but also they're going to be used for the automated processing. So for me, let's say that I applied, I am a traveler from Canada, I go to the EU, I got my ESTA authorization, my data are going to stay in that system for 3 years. So for 3 years, my data are fully available to assist in creating an algorithm or to be automated, checked every time any traveler applies for an authorization. So there is no kind of anonymization technique because the data of travelers or of foreigners in general are feeding into policy making. They are crucial and necessary in order to legitimize prior decisions and inform future decision making. So our data, they can't be anonymized, otherwise they lose their value for the EU legislature.
So I have a question. I don't see anything else, but as I asked, I'm sure other people can and should put their questions in the chat. But I do have a question that goes to this US-EU contrast. So in some level, it seems like what the EU is doing is quite tame in that it's like caged in this very nice way. Whereas we in the US, we routinely get newspaper reports about, for instance, this just came from a month ago or so, of ICE, which is the Immigration Enforcement Authority, buying privately available data on utility use from private data brokers and using it to enforce immigration laws. Because obviously, if you have a utility bill and don't have legal status, you're overstaying your legal status, and so you are subject to criminal and immigration enforcement. So that came out in the news, and it was stopped not because of the law, but because there's a congressman who said that's not fair. And this doesn't seem to happen in the EU. So I want for you to explore why it is that doesn't happen in the EU. And also to counter, playing devil's advocate here, some of the rhetoric out there about how the EU is falling behind because it doesn't have all this great data out there from the commercial sector that's being consolidated and used by all sorts of parties to develop machine learning algorithms, for instance, which are much more advanced in some ways compared to the ones you're talking about. And so the US has it because it doesn't have the same kind of privacy regulations, so you have all this great data, and the EU doesn't, and so it will fall behind in the global race, whatever that is. So if you could also talk to the normative aspect of that.
Francisca, these are amazing questions. There is some kind of this public-private partnership in immigration enforcement at the EU level as well, for instance, with universities having the registration system in order to report it to national authorities, and the national authorities then may check whether a student got a visa lawfully or was a pretext in order to come and work. So there is some kind of private-public partnership, but not to the extent that you mentioned. I think there is, this goes a little bit too far. And the main reason why I think this couldn't work under EU law is because under EU law, we have a principle that has been attacked quite a lot under data protection law in the past years, the principle of purpose limitation. And purpose limitation is under data protection law basically says that when you collect the data for a specific purpose, you cannot process the data for additional purposes which are incompatible with the primary purpose of the data collection. So this test of incompatibility, it is a bit flexible test. And that's why I'm saying that the principle has taken a hit in the past couple of decades with digital technologies, but there are certain limits. And what is the foreseeability for individuals when they have a bill and that bill ends up in authorities, in public authorities? For me, I find it a bit too much. And what is the expectation of privacy when someone in their own house pays or not pays the bills? At least in their own house, there is some kind of reasonable expectation of privacy, even should be under US law. For instance, when you have a relationship with the public authority, I may understand that the reasonable expectation of privacy, it becomes a bit lower. But within your house, with your home and how you pay your bills, I think that there should be a higher expectation of privacy, which means that under EU law, this couldn't necessarily work. And as to your final, the other comment that you're saying about how the EU is falling behind, actually, it's very interesting how there have been calls at the EU level to actually downgrade the protection of the GDPR, the General Data Protection Regulation, because it's not considered too flexible for collection of personal data at such mass level as in the US. So what you're saying has already gained some proponents in the EU, but there is quite a lot of backlash that really the GDPR and the EU data protection law is the quite high standard, and that should be the level playing field globally, rather than what is considered a bit lower standards of the US. Even though at the EU level, we try to create bridges between the two for sure.
Okay, so we have lots of questions here. We only have 4 more minutes, so let's see. Let me ask the next one in the queue. Here, this one is from Andronico Stiliano, and the question is, what access do governments have to this information? For instance, if this was enforced on the partition line in Cyprus, would the Cypriot government be able to use this information to target individuals who cross the occupied area and bring back goods to sell, contrary to Cypriot law?
If this was enforced on the partition side, would the Cypriot governments be able to use this information to target individuals who cross the occupied area and bring back goods to sell? Look, the case of Cyprus, it's a very complicated one because I didn't have the time to say so, but actually Cyprus is not a full member of Schengen, which means that these systems are not operational in Cyprus because of the partition between the two areas. And unless this is resolved, the systems are not going to be used. They could be used only sometimes on a read-only access, but a proper use by Cypriot authorities is not a possible, at least for the foreseeable future.
Okay, and I think we have time for one last one from Shalene Shaw, and that's the question on whether member states have developed their own AI regulation or whether they have just entirely deferred to the EU on this.
Okay, so thank you also very much about this question. The AI Act, the proposal for an AI Act is a horizontal one that is going to cut across many different areas. And we see that in the past few years, member states try to develop their own strategies, and there are initiatives, but there is no comprehensive legislation. And so at the moment, the primary resource is what is going to happen. Everyone is waiting what is going to happen at the EU level, not only at the European context, but also globally, I think. The Brussels effect is considered to be quite real, also with the example of the GDPR. So there are some examples. For instance, in Germany, I know for a fact that in immigration context, they use voice recognition technology, which is AI-based, which is outside the EU law. The AI Act will this voice recognition technology is going to fall within the scope of the AI Act. That's for sure. But other than that, not that many developments. At the moment, this is quite new. Okay,
well, unfortunately, we'll have to stop there. There are a couple extra questions in the chat, so maybe you can answer after the end of the session. But as all these questions bear witness to, it's been a really lively session. Thank you very much to the whole audience and for participating, and special thanks to you, Nyovi, Professor Vavula, for this terrific presentation. And so large virtual clapping, and thanks for explaining all of this complicated matter. Thank you.
Thank you very, very much to everyone who participated and attended this event, for the Dean Celorio for the invitation, Professor Binyami for chairing this session, and to anyone who wants to get in touch. If you Google my name, you will find my email account, and hopefully very soon you will see me around the law building as well. So feel free to come to me at any point. Okay, thank you so much once again.
Thank you. Bye-bye.